This is the court. My name is Nicholas Pena, and I am here to represent McCulloch. Here we are trying to understand the definition of federalism. We must know who has the greater power, the state's reserved power or the federally delegated power. As we all know, in Article 1, Section 8, Clause 5 of the Constitution, Congress has been given the power to borrow money, coin money, regulate the value of said money, regulate the value of foreign currency, and fix standards of weight and measures. Congress decided that the best way to enact this is through the national bank that can set up shops in states and be able to issue currency and promissory notes. The Second National Bank has been set by James William McCulloch, which was opened in Maryland, which Maryland decided in February of 1818 to pass a law which I believe surpasses the state's own reserve power. They are trying to supersede the federal government by taxation on a federal bank. Maryland is trying to show that the 10th Amendment is what gives them the power to tax us, since the power to create a bank was not specifically delegated as a federal power to the Congress. But the precedent has already been established for a national bank. Congress created the first national bank already in Philadelphia. That makes the second national bank that they already have the power to create the second national bank. And while Maryland may also claim sovereignty, ultimate sovereignty rests with the people, not the states. And if the people created the Constitution, therefore the Constitution in a sense is supreme over the states. And the Constitution is what delegates us our federally delegated powers. And the Congress, it has implied powers and can really interpret their implied powers however they like, as long as they do have a rational argument to go along with their implied powers. The Constitution is an expounding piece of paper, basically. The Constitution is what is being explained and even interpreted by the Congress, and is ultimately Congress's own right to interpret the Constitution. Therefore, it is within their own right to establish a national bank, while the state lacks the right to tax a federally established establishment such as the national bank. Which brings me to my last argument. Article 1, Section 8, Clause 18, as my partner already brought up, which is to make all laws which shall be necessary and proper for carrying into execution the foreign powers and all other powers vested by this Constitution in the government of the United States or in any department or officer therefore. Which is saying they have the right to make laws that are necessary and proper for foregoing laws, and all powers vested by the Constitution, such as the bank, Article 1, Section 8, Clause 5, they have the power to coin money and, well, basically all what a normal bank can and does do. This clause is found in the part of the Constitution that is expanding the delegated powers of the Congress. Therefore, I say the point of this clause is to expand the power of Congress, since it is not explicitly limited in the Constitution. Therefore, it is prohibited by the Congress to enact this second national bank. However, it does supersede the state's established rights to tax this federal bank.
He's trying to win.
He is.
I was like,
All right. Yep, go.
Ms. Chief Justice, and may it please the Court, my name is Victoria Childers, and I represent Maryland in this case. McCulloch is lobbying for a loose interpretation of the Constitution by saying it gave Congress the right to use all means necessary and proper to fulfill its responsibilities. But they are twisting the words of our founding fathers. The most capable and knowledgeable minds at the time came together to form our Constitution of the United States of America, even recognizing their initial failure with Articles of Confederation, and learning from their mistakes made to make the ideal fundamental principles for our new nation. It would be imprudent to attempt to interpret it any other way than it was precisely stated, in order to ensure the original values are not lost. The Constitution exactly states the power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively in the 10th Amendment. Even allowing more power to the federal government through the necessary and proper clause in Article 1, Section 8 of the Constitution, as McCulloch is trying to argue, a national bank is neither necessary nor proper. Their justification is that the bank will regulate interstate commerce, collect taxes, and borrow money, all enumerated powers given in the Article 1, Section 8, but a bank is not necessarily needed to execute these powers. Also, it is not entirely proper to delegate the regulation of those powers to a system that is specifically said to be in its own personal interest and not in the interest of America. The Second Bank of the United States is a profit-making, 80% private-owned entity, so it receives special privileges and advantages without being held completely accountable to the interests of the common people. The competition from the bank harms state-chartered banks by stealing private business. Because they use government-sanctioned advantages for personal gain, it is not unreasonable to expect them to give part of that money back to Maryland as they are taking business and taxable goods away from the people and the economy of the state. If the bank is truly a part of the national government, it should be concerning itself with the livelihood of the people rather than robbing them of their hard-earned incomes.
Yay.
Shots fired.